What about the Department of Employee Trust Funds?
Well, the plaintiffs have not challenged the provisions of Act 21 as it applies to any of the independent state agencies, of which the Department of Employee Trust Funds is one. I have not spent a lot of time analyzing or developing any arguments as to whether there may be other constitutional infirmities in Act 21 as it applies to agencies that are not, within the governor's control. I think, honestly, there may be an issue there, in part because Act 21 delegates such broad and untrammeled authority to the governor to shut down any kind of administrative rulemaking without any limitations on his discretion, without any standards, without any ability to have public input. There's no requirement of a public hearing or publication or anything of that sort for the governor to step in and say, it's not happening. So I do think that there are potentially some broader issues here, but again, our focus in this case is on the superintendent's authority.
Here's my problem on Thompson v. Craney. See if you can resolve this. Opposing counsel say that Thompson v. Craney really means you can't marginalize the powers of the Department of Public Instruction or the superintendent. You can't marginalize it. And there, the statute took away almost all the powers and left him with the title and sitting on the board or boards. Mm-hmm. Well, I keep rereading Thompson v. Craney, and Thompson v. Craney says, under our holding in the present case, the legislature may not give equal or superior authority to any other officer. This case does not require us to decide the extent to which the SPI's powers may be reduced by the legislature, and we reserve judgment on that issue. So they don't say, hey, you can take away all the rulemaking power from the legislature. Thompson v. Craney doesn't say that. Take away all the rulemaking power of the superintendent. In several places, Thompson v. Craney says that what you can't do is disperse the power of the superintendent. And they reserve judgment on everything else. Why am I not reading this correctly, and why aren't you emphasizing that?
Well, I think Your Honor, you are reading it correctly. And I think that what the court was commenting on there is that in a particular instance, let's say the legislature decided that it no longer wanted the superintendent to promulgate rules for teacher certification, but rather that the legislature wanted to enact legislation that had a sufficiently detailed and comprehensive scheme for certification of teachers that no rulemaking was necessary. The legislature, in my opinion, could take that set of rulemaking away from the superintendent and enact positive legislation that accomplished that goal. So I think what Thompson was saying is that in a particular area, as to particular duties and responsibilities that the legislature has prescribed by law to the superintendent, the legislature can take those things away or modify them or, add new duties and responsibilities. But what it can't do is, vis-a-vis another officer, shift control and power to another officer that's superior to the superintendent. And I think that, it is consistent within the four corners of the Thompson opinion. The court perhaps could have spelled out its reasoning a little more comprehensively in that part of the decision you're citing, but I think that it is consistent with the overall holding.
It seems to me you just used the phrases power and control as being synonyms. And as Justice Abrahamson, the section that she was just reading from, beginning at paragraph 19 of the Thompson, we note, however, that the constitutional difficulty with the education provisions of Act 27 is not that it takes power away from the office of SPI, but rather that it gives the power of, so in other words, it's giving control. And as Justice Abrahamson just pointed out, the court there reserved for another day the question of how much power, not control, that's established. And it's, but we are now wrestling with the question that it seems to me, we're now asked to address, and we have to wrestle with the question that the Thompson court put off to a different day. How much power can be taken away from the superintendent? So I think we go down a confusing, an unnecessarily confusing road that distracts from the issue if we say power and control are the same things. They're most definitely not, especially within this context. So narrowing in, I'm glad you said it because it brought to sharper focus in my mind the questions that we're going to have to address, and I invite your comment on how should we answer that question. You've been talking now, and you started out by saying, well, Thompson answers the question, and Thompson's been around for 20 years, and Thompson's good law, so no reason to change it. But now it seems to me that there's actually a lot sharper question that Thompson did not address, and we have to address now. How would you like us to answer that question? How much power can the legislature redirect from SPI to a different agency? And how is the rulemaking authority of the legislature implicated by your answer?
Well, just to take a step back to the beginning of your comments, Your Honor, I think that power and control are very interrelated concepts because
Of course they're interrelated, but they're not synonymous.
Because you have to have power to be able to exercise control. And the issue here is that the legislature has delegated rulemaking duties and responsibilities to the superintendent, but it has given to the governor the powers to control that exercise of rulemaking by the superintendent.
Okay,
If
but
the governor
that
says you
wasn't
can't
the
do it, you
question
can't
in
do it.
Thompson, with all due respect, to use your phrase. That wasn't the question in Thompson. The question in Thompson was an act that gave the power of supervision to somebody other than the superintendent. That's the question addressed there. Look, I don't want, this is not hostile questioning. I'm trying to explore with you the important question that is coming into focus as we're discussing, and I'm trying to give you an opportunity, and if you can't think of one, that's fine.
Your Honor, I'm doing my best to try to answer your questions. I'm still unsure of what the distinction is that you're
Okay,
drawing.
sure. The issue, and I'll try it once again, and then if we're just two ships passing in the night, then that'll be for us to talk about in the conference room. The issue in Thompson, it seems to me, was a wholesale transfer of all of the supervisory control to someone other than the constitutional repository. There he is, the temporary one, Mr. Evers, sitting behind you in the front row. So that, unconstitutional. Question left for a different day under Thompson is, and this was Justice Abrahamson's question a few minutes ago, how much power, it didn't slam the door on the legislature, nor do I think it could have, but it didn't slam the door on the legislature from exercising any power as opposed to a transfer of control. So the question we're going to be having to wrestle with is how much power can the legislature, by means of its proper exercise of the rulemaking authority, delegate or modify its rulemaking so as to permit another constitutional officer to share the power, not to take control of the supervisory obligations.
Your Honor, I think the fundamental concern I have about the way you framed the issue is that you're characterizing the regime that's set up under Act 21 as a sharing of power between or not sure if you use the word control or power here, but sharing between the governor and the superintendent, when in fact, what the legislation does is says that the superintendent must get the approval of the governor in order to even draft a rule. And that places the governor in a superior position to the superintendent.
I can see your point. I see your point, and it's a good one. I didn't state it with as precision, with as much precision as I should have. What I was getting at was the sharing from my eye and from what my job is going to be once we start fashioning a rule for this case is not between the two people you are immediately concerned about, the governor and the superintendent, which is, again, I share concern in general for all parties who appear in this court. The sharing, in my eye, is being divvied up, for lack of a more nicer sounding word, it's being allocated by the legislature. And allocation of power was not foreclosed by Thompson. And so it seems to me the legislature, taking a look at Thompson, says, well, we can't transfer all supervisory control to someone not the superintendent. We all agree with that, right? You agree with me? Yes? I'm looking for one note of accord here.
Yes, I agree.
Throw me a bone. But the question then left is, what can the legislature do? Because we have to be mindful of the legislative authority as well as the powers between the two. That's what I'm talking about when I'm using the word sharing.
Let me try to answer that, Your Honor.
It's actually an allocation instead of sharing.
Allocation of power to the governor
From the
legislature.
By means of the rulemaking authority to allocate the power between the SPI and the governor.
I believe that it is drawing a distinction without a difference to describe the role that is assigned to the governor by Act 21 as an allocation of power rather than giving the governor power or putting the governor in control of rulemaking by the superintendent. Because what the legislature has done is to prescribe rulemaking authority to the superintendent, but has required the superintendent to go to the governor to get the governor's permission to carry out that legislatively assigned duty.
Carry out one facet of the superintendent's authority. And
Rulemaking, what does the superintendent do to carry out supervision of public instruction? And are any of those things shared?
Well,
That might be a different way of asking a similar question.
no, I think that's helpful.
no, I think it's helpful too. And earlier in the argument when Mr. Meany was presenting his case, the court engaged in a colloquy about the definition of rulemaking that's in the statutes. Rulemaking is a very broad concept, and whenever a state agency, or in this case the superintendent, wants to set a standard, have a generally applicable order, establish procedures for the agency to carry out its administrative functions, or to have a statement of policy, or to interpret a statute in a way that's going to have general applicability, a rule must be promulgated. that doesn't leave a lot of room for the superintendent to take actions to administer the public education system outside of rulemaking. Certainly, Thompson discusses the kind of hortatory role that the superintendent can play in, encouraging public education and visiting schools and lobbying and advocating for public instruction, and that role does not require rulemaking. But, as Thompson made it very clear, the framers envisioned a much broader role for the superintendent than that.
How do you reconcile your argument with the pronouncement in the Fortney case that Article 10, Section 1 confers no more authority upon those officers, including the school superintendent, than must be delineated by statute,
Is your question about that discussion in Fortney versus the discussion of the superintendent's role in Thompson? How those are reconciled? Well, I think that, the Fortney court was looking at a much narrower question. That case involved an issue about whether, I believe it was whether local officials can be bound by provisions in Chapter 111 that had to do with collective bargaining, and whether the local officials were bound by the agreements that they entered under collective bargaining. That case did not deal with a dispute involving the superintendent's authority vis-a-vis some other state official or local official even. It had to do with whether the legislature can enact laws that prescribe duties and responsibilities to those local officials. I think that's consistent with Thompson, and what Thompson addresses this, and I think that this is going back to the language that Justice Gableman was talking about, that there is a portion of Thompson right at the end of the decision that raises the question of to what extent can the legislature take away duties and responsibilities from the superintendent, or to what extent is there some vested authority under the Constitution that trumps the legislature's ability to do that? And I see my red light is on, Your Honor.
You may finish the answer. Are you finished?
All right,
with
thank
it?
you. So I don't think that those two cases are in tension. The issue that was being addressed in Thompson, was certainly a broader issue and a different issue because it was examining the superintendent's authority vis-a-vis other officers, and it wasn't this kind of narrow and focused discussion of whether the legislature can prescribe duties for local officials.
Wouldn't your interpretation of the vesting clause of Article 10, Section 1, in effect, though, swallow the legislature's power to prescribe the duties and powers of the superintendent?
No, Your Honor, because this is, it's no different really with the superintendent than it is with the governor. The governor cannot exercise executive power unless there is a law that has been duly enacted by the legislature. That's what executives do. They carry out, they give effect to laws enacted by the legislature. The superintendent, likewise, is carrying out and giving effect to laws enacted by the legislature. The legislature determines what his duties and responsibilities are by, for example, giving him the responsibility to carry out teacher certification, graduation standards, standards for assistance of disabled students, et cetera, et cetera. It has very broadly defined the superintendent's responsibilities to administer an education system that is consistent with the policy direction as established by the legislature.
Isn't Act 21 really a modification of the powers and duties of the superintendent?
I believe that it is not a modification of those duties. It does not take away his authority to promulgate rules in any specific area. It simply says that his responsibilities in those areas are subordinate to the governor. He must go to the governor to get approval before carrying out any of those statutorily prescribed duties.
But if the governor doesn't approve of the rule that the superintendent wishes to promulgate, the superintendent can go back to the legislature and has therefore another avenue for implementing a
Sure,
rule.
he can lobby. He cannot introduce a bill. The legislature can fix it by executing legislative powers. The superintendent cannot. He has no ability to enact legislation. He can ask, they can turn him down.
You have a question?
I want to explore the same kind of thing that some other people are exploring. Would you agree that the authority to license teachers could be changed to, could be transferred, say, to the Department of Safety and Professional Responsibility by legislation?
I believe that that would present similar constitutional issues to those in this case, because it would take a central part of the supervision of public instruction out of the sphere of the superintendent and place it in a cabinet agency where the governor has control over it. So I do think that that would raise some questions. Now, I can also think of a framework where that would not be the case. For example, suppose that legislation was enacted that gave the Department of, which one, Safety and
Safety and Professional
Professional,
Responsibility.
I'm sorry, yeah, would allow that agency to propose rules, to draft rules, but then gave the superintendent the authority, as is kind of the flip side of Act 21 here, gave the superintendent the authority to approve or disapprove those rules and decide whether they're submitted to the legislature for approval. I think that would be constitutionally okay and consistent with Act 10, Section 1.
I have a question. I'm sorry.
If I
They're
may.
still going. Go ahead.
I think your answer is giving me, I didn't appreciate that that was the answer that you were going to give me. I think you are now arguing that there are some absolutely core functions to the superintendent of public instruction that could not be taken away from the superintendent, even by clear legislation approved by the governor. And I thought your argument was a little bit different, that the legislature might transfer a duty away from the superintendent, but so long as the legislature does not clearly transfer that duty, the superintendent has the duty, and we can't have another executive officer simply impeding and frustrating the implementation of that duty or the exercise of that duty. Tell me why I'm wrong.
Well, I don't think you're wrong, Your Honor. The hypothetical that you proposed asked what I thought would happen if the legislature assigned rulemaking over teacher certification to another state agency, and under your hypothetical really would entirely cut the superintendent out of that process. I think that's what you were implying. I believe that the certification of teachers is very well within the sphere of the supervision of public instruction that is constitutionally vested in the superintendent, and that the legislature could not carve that out of the superintendent's authority and give it to another executive branch agency. I think that there probably are some gray areas, some fuzzy areas where it's not really clear whether a particular function is squarely within the supervision of public instruction or not. But when you look at teacher certification in particular, the very first laws that were enacted by the legislature after the Constitution was adopted gave the superintendent the responsibility to determine the standards for teacher certification, and I do think that that falls within his sphere and could not be taken from his control and handed to another part of the executive branch.
Now, I understand you weren't around in 1848.
True.
But were you?
Some days it feels like it.
Accused of that, yes.
Closer, maybe.
The functions that were assigned to the superintendent in 1848, were any of those functions exercised according to rules? Not maybe kind of formal
Yes,
administrative
in-
rules, but I mean,
Yes.
did they have any guidelines, checklists, something?
In some of those first laws that were enacted both after the 1848 Constitution and also after the 1902 amendments, and the court in Thompson looks at both, there was legislation requiring the superintendent to create rules. Something called the school laws, the superintendent was required to develop. I have been unable to determine what was meant by the school laws. I am speculating that those would be a set of regulations that schools would follow in carrying out their functions. There were also requirements in that very early legislation that the superintendent develop rules for carrying out their processes and procedures as defined by the legislature, and again, that's quite similar to today, which under current law, those would have to go through a rulemaking process. And rulemaking, administrative rulemaking in 1848, granted, was not the same as it is now. It wasn't as developed. It wasn't as, the procedures were not as rigorous as they now are, but certainly in those very early laws, it was anticipated that the superintendent would set rules that the schools would follow. Thank you.
I have a comment, and see if I understand your argument. It was my understanding from your brief that you view Thompson v. Craney as a dispersal of power. That is, that the legislature could not give superintendent powers to other officers to the extent that they became superior. That may not be the right word, superior to the superintendent. It was a dispersal of power case.
Yes,
Is that right?
I think so, yes. I hesitate a little bit because the word dispersal,
Okay.
to me, suggests something a little more amorphous, but what I believe Thompson is saying is that the superintendent, because he has vested constitutional authority to supervise public instruction, is, the executive powers in carrying that out are assigned to him, not to the governor.
Okay. All right, that's well stated. That's what I intend. And that's how I read your brief. You then, Justice Prosser asked you a question about his made-up Department of Licensing, right? Professional. It is the Department of Licensing, okay.
It
There is a
exists.
Department of
Yeah.
Licensing, and there's a nice name to it now. It's changed since last I
Right,
looked.
yes, I still think of it as regulation and licensing.
And it seems to me that your response to him caught him by surprise, and it did me too. But when you then explained it further, that too was a distribution of a power that the superintendent had, and now a new person has it. And so the question is, you have to do a comparison between the two.
Right,
Is that right?
I think that's right, right.
So that, to me, fit in with what your argument in the brief was.
Okay.
And I think you've tried very hard not to get into the question that Thompson v. Craney reserved for another day.
I don't think that the court needs to address the issue that Thompson reserved for another day.
That's right. And what do you think is the issue that Thompson v. Craney reserved for another day?
I think the issue that Thompson reserved is whether, if the legislature just decided that it was done with the superintendent and started systematically pulling back all of his duties and responsibilities, at some point, is there a limit on the legislature's ability to do that?
Right, and that if they took away responsibility and gave it to no one else,
Right.
then that's the issue that wasn't touched in Thompson.
That's the way I
Craney.
see it, yes.
When they give that responsibility to someone else, then you're within Thompson v. Craney,
Right.
because then you have to compare, in
Right.
your view and in Thompson v. Craney's view, you have to compare the powers of the superintendent and the new entity or existing entity that has now gotten powers that were with the superintendent.
Yes.
I understand that.
I wonder what source you and Justice Abrahamson have for that. What I'm looking at is the plain language of the case. This case does not require us to decide the extent to which SPI's powers may be reduced by the legislature, and we reserve judgment on that issue. Now, unless I misunderstood your many responses to me on the question, you take the firm position that the act reduces the power. It adds to the power of the governor at the expense of the superintendent. Yes?
Yes, and it does so by putting the governor
Then
in a superior position to the
how do you
superintendent.
get all of that? How do you get that sophisticated, detailed reading of the question reserved for a different day when the only thing that was said was we leave to decide the extent to which the SPI's powers may be reduced by the legislature for a different day?
Well, because the issue that was before the court in Thompson was what the superintendent's powers were vis-à-vis other state officers. In that case, it was a Secretary of Education that was
I think said a little more
created.
directly, could the powers of the superintendent be transferred to the secretary?
Yes, that's what that particular
A
act is.
wholesale transfer of power.
And I think it's, important to note that Thompson versus Craney did not pick and choose. Those changes were enacted in a budget bill that had hundreds of statutory changes. The court did not pick and choose and say, well, this one can be transferred, this one can't, and engage in that kind of a, as the Court of Appeals called it, a stick counting analysis.
So
It
does
said that
that-
the general principle here is that
General principle. Go
the
ahead.
general principle here is that the superintendent cannot be made subordinate to another officer in exercising the duties of public
I
instruction.
thought the holding was, and your previous answers to my questions seemed, agreed with it, that Thompson said you could not transfer wholesale power from the SPI to the secretary. And now from that, you say this instance is directly analogous to the wholesale transfer of the powers of the superintendent. So therefore, now you're back to, we need look no further than to Thompson to decide this case. Is that your position now?
Our position throughout has been that this court need look no further than Thompson. We
the
believe
answer to my-
Thompson is on all fours and resolves the issue presented to the
I
court.
understand.
Thank you very much.
Thank you.
Good morning. May it please the court, my name is Ryan Elsestuen, and I represent the defendant respondent, State Superintendent of Public Instruction, Dr. Anthony Evers, who, as has been noted, also appears here personally today. Dr. Evers? This case focuses on the ability of the state superintendent to supervise public instruction. Rulemaking plays a central role in that supervision for several reasons. First, rulemaking has been part of the state superintendent's rulemaking authority since statehood. The very first law related to the state superintendent gave the state superintendent rulemaking authority to develop rules to hear appeals made to him. Second, the legislature recognizes that rulemaking is necessary for the supervision of public instruction. We've talked extensively here today about the definition of what a rule is and how broad it is, but there's also other sources that show how necessary and central rulemaking is to supervision. There's more than 70 statutes that explicitly require the superintendent to engage in rulemaking in order to enforce and administer them. Further, under WSStat 227.10, the superintendent is required to promulgate a rule in order to enforce and administer the statutes. So in order to enforce or administer the teacher licensing statutes or the laws related to special education or school finance, the state superintendent must promulgate a rule in order to do so. The reason why Act 21 runs afoul of Thompson v. Craney is because the state superintendent previously had the ability to approve a scope statement and approve when a rule went to the legislature. In Thompson v. Craney, the legislation there transferred power from the state superintendent to the Secretary of Education. That's exactly what Act 21 does with rulemaking. It moves the state superintendent's ability to approve a scope statement, to submit a rule to the legislature, to the governor, and other officer. And the state superintendent is thus made subordinate. The state superintendent has no way to overcome the governor's decision not to approve a rule. They are not equals, as the state has argued in its initial brief.
Counselor, could the legislature have simply enacted 227-19, and there are a couple of references in there to the governor, but essentially it requires that rulemaking be submitted to the legislature, and then sometimes it's referred to committee and so on and so forth. Could the legislature simply had done that and not enacted 227-135? Would there be a problem from the secretary's perspective?
The legislature could have done a number of things in order to make this permissible. The state superintendent, we are not challenging the ability of the legislature to review rules. Under Coyne v. Walker and the Court of Appeals decision, the legislature will still review it. The state superintendent will still be required to submit it to the legislature for review. The problem with Act 21, however, is it puts an other officer in charge of the rulemaking process, which is the governor. And I'd like to point out, too, that the problem with Act 21 is not just the Thompson v. Craney problem, but it's also that the framers never intended the governor to be an other officer of supervision of public instruction. And there's several reasons for this. First, in the constitutional debates in 1848, it was directly presented to the convention a proposal to put the governor in charge of the state superintendent, to have the governor approve or appoint the state superintendent. The convention rejected that. The very first law that was passed in 1848 related to the state superintendent, the governor was given no power or authority over public instruction. That was solely to the state superintendent. And you can also look at the structure of the Constitution itself. We've been focusing on the first sentence of Article 10, Section 1, but also the last sentence of Article 10, Section 1 says the term of office, time and manner of electing and appointing all other officers of supervision of public instruction shall be fixed by law.
Counselor, I never think of myself as an agency. And of course, if I go and look in 227 as a definition of agency, it does omit judicial officers. And I frankly hadn't thought about the secretary as an agency either. If that definition in 227 were interpreted to not apply to the secretary, how would that affect 227-135, which speaks to the acts of an agency, which I assumed when I was reading it was DPI? I didn't think it was the governor until I went back and I read the definitions and how broad it was stated. But if I interpreted agency as not including I meant the secretary, not including the secretary.
You mean superintendent, or?
I mean the superintendent, sorry, I'm giving him the different title. Okay, I call him SPI all the time, so I should just use my own initials. Okay, if I look at 227-135, it uses the word agency. And when I was first reading it and getting ready for this case, I thought it was Department of Public Instruction, because to me that's an agency. I had not thought about the superintendent being, quote, an agency, because I'm not an agency. Then I went back and I read the definition in the statute. I agree the definition is very broad. If the definition were interpreted by this court to exclude the superintendent of public instruction, what would be your thoughts on the constitutionality of the statutes that you're challenging?
Sure, I think that's a very good point. It's hard to separate the Department of Public Instruction from the state superintendent. I think that's the issue here, and the statutes even flip back and forth between whether it's the state superintendent carries out a certain statutory power or it's the Department of Public Instruction. I think the circuit court said it best, where the state superintendent supervises public instruction by overseeing and running the Department of Public Instruction, which is an agency, is under the definition under 22701. It's clearly an agency. And so it's hard to separate those two, because that is the primary means that the state superintendent uses to supervise public instruction, is running the Department of Public Instruction, and the Department of Public Instruction, like all administrative agencies, functions and operates by promulgating and following administrative rules.
So what you're saying to me, it doesn't make any difference.
Correct.
I have to think about that a little bit, but thank you.
Counsel, your argument, as I understand it, is not a separation of powers argument. Your argument is not a core function argument. Your argument rests on the other officers and how it's interpreted in Thompson.
Correct.
That's it.
Correct, and I think actually the state tries to divert this attention in making a separation of powers argument, but this isn't about the legislative character of rulemaking. Supervision is vested in the state superintendent, and Article 10 and Thompson don't differentiate between whether a certain statutory supervisory power is executive in nature, is quasi-judicial in nature, or legislative in nature. And again, looking back at that very first law enacted in 1848, the superintendent had all of those powers under that very first law. He was required to hear appeals made to him, a quasi-judicial power. He's required to promulgate laws in addition to his executive powers. And so it simply doesn't fit in this nice separation of powers framework. In addition, this raises significant issues following the state's lead about the constitutionality of Act 21 overall, because then it requires this court to look at whether it's a permissible delegation of legislative power.
Why isn't it a separation of powers issue? I think it's just a matter of lens, what angle you're looking at the issue. You can advance the argument that it is the legislature, as I think your opposing counsel does, it is the legislature that confers the power here.
Correct.
And so that it is a separation of powers issue.
But the exercise of that power happens solely in the executive branch. And so this is simply, the governor is the one who exercises this power, not the legislature. The legislature has no control whatsoever in the governor in this situation. The state attempts to make it sound like as if the governor is an agent of the legislature, that he provides a procedural check. But Act 21 doesn't contain any procedural checks. It doesn't contain any standards. It leaves it up simply to the governor's discretion on whether or not he approves a law. And it's helpful for this court to look at his prior decisions on the delegation of legislative power, where this court has explicitly and repeatedly required proper standards or procedures on any delegation of legislative power, including to entities that review rules. So in Martinez versus the Department of Industry, Labor, and Human Relations, this court looked very carefully at JCRAR, a legislative entity, to see whether the legislature had properly delegated authority to JCRAR. And one of the reasons why the court found that permissible was that the legislature had established 7 different statutory standards for which JCRAR to act. JCRAR couldn't act unilaterally. It had to act within certain time frames. By contrast, Act 21 does nothing in terms of the governor. He doesn't have to act within a certain time frame. The only standard is Act 21 says it's up to his discretion, which is no standard whatsoever.
Well, if you're talking about separation of powers and delegation, the delegation here, as I understand it, is from the legislature to the governor. There's no delegation here from the legislature to the superintendent of public instruction.
Correct.
That's your basic argument, isn't it?
Correct. The legislature is not involved.
Well, only because this is between the governor and, from your perspective, the governor and the superintendent of public instruction, because the legislature has acted to divide powers between them.
Correct.
And I looked in your brief to see where you differed from the Coyne brief, and I couldn't find a difference. As I read your brief, again, if I'm wrong, you should correct me. When I read your brief, I look at page 21 in your final statement. Regardless if one views rulemaking as part of the superintendent's supervisory power or a tool necessary to carry out these powers, Act 21 impermissibly makes the governor another officer superior to the superintendent in rulemaking. As such, it's unconstitutional as applied to the superintendent, and although you don't cite it there, the references to Craney. I'm assuming that. Is that right?
Correct.
Do you differ from the Craney brief?
No. State superintendent, I think it's a very simple framework on how to address the question before the court. The question is simply whether the state superintendent can be subordinate to the governor in the process to make administrative rules that supervise public instruction. It's the superintendent's position that Thompson v. Craney directly addressed the question about whether you can transfer a power previously given to the state superintendent and whether that can be transferred over to the governor and other officer. And as I previously stated, this raises numerous issues, not only in terms of Thompson v. Craney, but the plain language of Article 10, Section 1.
And you read Thompson, I'm looking at page 18. The Thompson court held the legislature, in quotes, may not give equal or superior authority to any other officer. That's the whole problem here.
Exactly.
You got another officer. That other officer happens to be the governor.
Correct.
And then the next paragraph expands on that.
So if we just X'd out the word governor in these statutes, you'd be happy, right?
If the governor wasn't correct, if the governor, most of the provisions of Act 21 are not at stake here.
Right.
Act 21 made numerous changes. We are simply challenging the very specific portions of Act 21, which puts the governor, in certain cases, the Secretary of the Department of Administration, in a superior position. But if you X those out, it would be completely permissible. And as I said,
What about if DPI submitted a rule to the legislature, as 22719 requires, and the legislature looked at it, looked at committees, and part of their process was to get input from the governor on whether the governor thought it was an appropriate policy for the state. You wouldn't have any problem with that.
no, the governor, like any other executive officer, just like the state superintendent, he's free to lobby the legislature. He can provide his input on that. But the legislature, again, the problem with Act 21 is another officer. The problem isn't with the legislature's review of administrative rules.
What about if the act was interpreted such that instead of the governor having a veto, he had a power of consultation with the superintendent? Would that cause a problem?
I think that would be much more permissible. because, again, the governor wouldn't unilaterally be able to overrule the state superintendent. If he,
So in that power of consultation, if the governor said, gosh, I just don't think this is a good rule at all, and that was his message to the legislature, then it was submitted to the legislature under 227-19, that would be okay, and it'd be up to the legislature to
Correct.
decide what they're going to do.
It's the same, the governor could have done that before Act 21, though, correct? I mean, the governor could have reviewed a rule, could
I'm
have
not
sent.
I'm not an authority on what the governor
Well,
can
I
do.
think it's also helpful for this court just to be aware of, Act 20, or before Act 21, the state superintendent had to follow very strict procedural requirements. This isn't about the state superintendent being able to promulgate rules willy-nilly. The state superintendent still must follow the very strict procedural requirements of Chapter 227, because again, this court required such procedural requirements in a delegation of legislative authority, and one of those is review by JCRAR, and the governor was free at any time to voice his displeasure about a specific rule. But again, he's not exercising unilateral authority over the state superintendent.
Okay, thank you.
May I just
Yes, sure.
clarify? I'm not sure what power of consultation is, but to the extent that you know what it is, and I've just not dealt with that concept a lot in statutes. You seem to say that it would be okay to have a power of consultation, yet I thought your whole argument was let's stand on the footings of Thompson, which says you cannot give to another officer shared or equal powers. Whatever this power of consultation is, would it be okay? I'm not sure what it is, but how does that interact with a prohibition against sharing powers with another officer?
Sure, I think it would be important to clarify exactly what consultation is. If it's simply the state superintendent has to present a proposed rule to the governor and the governor had to issue an opinion within so many days or something to that effect, it would be fine. The problem, again, though, is with Act 21 is that the governor unilaterally acts. There's no consultation. There's no way for the state superintendent to override the governor. There's no way even for the legislature to override the governor's decision. And, this leads to another point where it puts the state superintendent in a very difficult position. It shows why Act 21 runs afoul of Thompson, is that the state superintendent's required by law to promulgate rules all the time. And so when the governor refuses to approve a rule, the state superintendent has a choice. He can either yield to the governor's will and make the changes the governor wants, if the governor even wants any, or he can defy the will of the legislature and not promulgate that rule. So I think, while I think it's important to clarify what consultation is, the facts before this court, it's very clear what the relationship is between the state superintendent and the governor.
I ask you a hypothetical question. Let's go back to 1848. The state superintendent of public instruction is a constitutional officer. The legislature doesn't get around to passing legislation for 10 years. So he's the superintendent of public instruction, but there's no guidance from the legislature. Is there any sort of inherent power to fashion rules? Because I think the Assistant Attorney General here is saying all of this is legislative power, and the legislature can take it back, and it has to delegate it in the first place.
Yeah, I think that's an interesting hypothetical because, one of the three Polk County factors is the very first law related to the constitutional provision. And, the assumption under using that as an interpretation is that, especially at the 1848 debate, many of the legislators were in the constitutional debates. So, the intent of the debate is carried through that legislature. And in your hypothetical, that would make it more difficult to know exactly what the superintendent's supervisory power is, because you'd be deprived of that third Polk County, or the second Polk County factor. Instead, we'd have to rely simply on the plain language of Article 10, Section 1, and on the constitutional debates. But, fortunately for this court is we do have that 1848 law, which clearly prescribed rulemaking authority to the state superintendent, among other types of powers that were prescribed to the state superintendent. And, it should be noted that in Thompson v. Craney, they carefully looked at the plain language, but they also looked very in-depth on the constitutional debates and these first laws that were enacted, and they found those second two to be most informative and most illustrative in terms of what the state superintendent's supervisory power entails.
Thank you.
Thank you.
May it please the court, my name is Mike Julka. I'm from the firm of Boardman and Clark, and here today as representing Amici.
You'll have to speak up.
Oh, I'm
counsel,
sorry.
please.
Move the mic up or something. Our sound system is really bad for us.
I'm
up
sorry,
here.
let me,
No, it's not your fault.
no,
It's
no,
the
let me
sound
lean
system.
into this a little bit, I'm sorry. I'm here representing the amici in this case that supports the holding of the Court of Appeals, the Wisconsin Association of School Boards, and the School Administrators Alliance. And I'm going to take a very traditional amicus approach to this argument. You've heard very compelling arguments with regard to the case. And what I want to do is take a traditional amicus approach and talk to you simply about some policy considerations that I think are particularly relevant to your consideration. First off, what is the Wisconsin Association of School Boards? Because that's relevant to where I'm coming from. And it's a organization, a nonprofit organization that represents all but one of the 424 school districts in the state of Wisconsin. What's the School Administrators Alliance? It's an organization that represents 5 different organizations of administrators in public schools. So you've got the School District Administrators Association, the School Principals Association, the School Business Officers Association, the Human Resource Association, and you've got the curriculum people. So I'm here really to say to you that this, what I don't want you to do is lose sight of this case, that it's solely about education. It's solely about the question of State Superintendent of Public Instruction and the effect that that may have in terms of your ruling on educational, the educational future of this state. My clients have one mission, and that's to provide the best education to the pupils of the state of Wisconsin that's possible. And from our perspective and the perspective of our clients, the way to do that is to make sure that Article 10, Section 1, which vests in the state superintendent the authority, or I'm sorry, the supervision of public instruction, that is given the clear meaning and certainly the meaning that was given to it in Craney. It shouldn't be lost on the court, I guess, from my perspective, that essentially the whole educational establishment is represented here in support of the Court of Appeals and the unconstitutionality of Act 21. Not only are the clients that I represent, but also we have a letter attached to our brief of support from, for example, the Wisconsin Rural Schools Association, the Retired Teachers Association, the PTA, and Council for WEAC, the teachers organization, has been instrumental as well as in being co-counsel for the plaintiffs in this matter. So I think it's important for you to think about the fact that the educational, institutional, and establishment here is represented all in one very important perspective. And why is that? And I think it's because This is, the legislation, Act 21, attempts to fix something with regard to education now that's not broken. It's not broken. As it applies to education, that's all we're here about. Education is working well. The organizations I represent work very well with Mr. Evers and his agency. They collaborate. They work on rulemaking together. That's the way that education is advanced in this state. Secondly, the importance of education was obvious to the framers. I don't think anybody's mentioned, but and I don't know how relevant it is, but we all know that the United States Constitution doesn't mention education. So as Wisconsin was going through the opportunity and actually the exercise of creating its own Constitution, it realized, and the debates and the consideration foster that it realized that it had to deal with education in a very instrumental way. And at the time, things were fragmented in Wisconsin with regard to education. And I would commend to your reading pages 11 and 12 of the defendant respondent's DPI brief with regard to what was going on at the time with regard to the fragmentation of education, the fact that it needed to be uniform. I see my light is on. I'm going to conclude by simply saying I think there's a value of consistency whenever you have a nonpartisan, a public official like the state superintendent, as opposed to a partisan officer such as the governor who may be reviewing rules.
Thank you.
Thank you very much.
Yes, you may proceed. I've been trying to keep time, as you folks know. I believe and my marshal has been trying to help me out too, so I believe Attorney Crawford used up the extra 20 minutes, and then according to my watch, which isn't a stopwatch, there was an additional 9 minutes given to the respondent's time. So I'd like that added on to the rebuttal time in this case, so you'll have more than your 5 minutes. I'm trying very hard to keep it even, and it's not a problem of counsel. You all are very, very good, but we are trying hard to be fair to both sides in the time manner, so please proceed.
Your Honor, if I could just ask what your thinking is as to what time I actually have, just so I may know that.
14 minutes, Tina, 14 minutes. And
Thank
she'll give you the yellow light when you've got 5 to go, so you'll be able to judge for yourself a little bit.
Thank you, Your Honor. I'd like to address some of the responses that have been made by counsel for the respondents. First, our position is, and this is based on the clear language of Article 10, Section 1, that there are no inherent powers vested in the superintendent. The superintendent has a supervisory power, but what is composed within that, or included within that supervisory power, is, as the language of Article 10 states clearly, to be prescribed by law by the legislature. The state defendants believed that this issue had been put to rest by the concessions that we've outlined, the concessions made by the respondents, that the legislature has the power to give certain duties and powers to the superintendent and to take them away, including the power at issue here, the power to promulgate administrative rules. We thought that had clearly been settled through admissions, through our briefs and admissions by the respondents. It was surprising then to hear Ms. Crawford's response to the hypothetical posed by Justice Prosser with respect to potentially moving the ability to license teachers or certify teachers away from the superintendent of public instruction and give that power to another officer. That is clearly what happened historically since 1848. As Mr. Essenberg's brief lays out, the legislature in 1848, after the passage of the Constitution, the ratification, gave town superintendents, not the superintendent of public instruction, the exclusive power to license school teachers. And in between 1862 and 1868, county and town supervisors shared that licensing certification power. It wasn't until 1939 that the legislature chose, as it was authorized to do under Article 10, Section 1, to give that power to the superintendent. So again, I think this points out that there are no inherent powers. That is not to say that the legislature, and this goes to the question posed by Justice Abramson as to the reservation at the end of the majority's opinion in Thompson, saying that the court was not passing on the extent to which, the ultimate extent to which the legislature could remove powers. It doesn't conflict with that, because that analysis would be based on, for example, what happened in Act 27, which was the subject in Thompson. The question would be, if all powers were taken away from the superintendent, then you would have to look at whether or not that conflicted with the grant of supervisory power to the superintendent in Article 10, Section 1.
Counselor, do you think there's any way of interpreting the statute such that the governor has a consultative power with the superintendent rather than a veto power over rules that the superintendent through DPI may want to have enacted?
The statute provides that the governor has to approve, for example, at the outset, the scope statement. So I don't believe that could be reasonably construed as a consultative role. The legislature could, of course, decided on that procedure. It decided in its judgment not to delegate part of the administrative rulemaking to the governor in two instances that are at issue here.
Okay, thank you.
Could you respond to the argument that this is an unlawful delegation of legislative power to the executive branch?
Well, first of all, Justice Bradley, I would point out that that issue was not raised in this case until the reply that we received in this case, and maybe in the briefs by respondents. It was not raised in any response to the petition, so we don't believe that that issue is timely at all. We believe with the protections that are in place, and primarily the one which I stressed to Justice Gableman, that ultimately there is a check on the governor's power here available to the superintendent to go to the legislature, and if the legislature agrees that the proposed scope statement or proposed final rule is something that the legislature believes that the superintendent and the department should have, that can be accomplished by statute. Again, the respondents don't contest the ability, and as they can't under the Martinez case, that the legislature still here has the ultimate authority, whether or not to adopt or let go into effect the administrative rules proposed by the agencies.
Thank you.
Counsel said there was not a lot to do outside of rulemaking when I asked her that question. What do you think of that?
Well, we disagree.
What else is there?
Well, there's the total administration of the Department of Education on a day-to-day basis. The department administers statutes. It administers existing administrative rules. And to say that Act 21, which applies to potentially future administrative rules, totally destroys the ability of the superintendent to supervise public education or supervise the Department of Public Instruction, we just don't believe that there's any validity to that argument. What you've heard from respondents as far as...
Counsel, I'm a little concerned with the effect of Act 21, according to you, that the governor could prevent the director of state courts from promulgating rules.
Your Honor, I would, again, I would go to the agency analysis that Chief Justice Rogan said, whether there's an application there. I believe there are rules there, but the state courts would have the same. And again, this does not go to inherent authority, constitutional authority of the court system, but to the extent that the Director of State Courts was attempting to propose a standard administrative rule, and Act 21 would apply, the courts would still have the same option of going to the legislature. To the extent, again, that it is an appropriate administrative rules process, and an administrative rules process may not be applicable to something that the state director of state courts was attempting to implement.
Well, it says agency doesn't mean a judicial officer. I don't know if the director's a judicial officer or that only means judges. Or does it mean the entire court system?
Your Honor, frankly, as far as whether a judicial officer also applies to the director of state courts, we have not taken a position on that. We are not advancing any position in the state which we would believe conflicts with the constitutional power of the state courts.
You don't want to get involved with us.
That's smart.
Counsel, I thought I heard the phrase executive order earlier in these proceedings, and that caught my ear. Is there a mechanism the superintendent can use called an executive order or something similar to it?
I'm not aware of that process, Your Honor.
So probably anything relating to policy directives of the superintendent that would not involve rulemaking would go to advancing the administrative parts of the position of both supervising employees, making sure that the internal policies of the department are being carried out. Anything having to do with the interpretation and advancement of the legislative directors would have to be done through the rulemaking authority. Is that fair to say?
Under the requirements of Chapter 227.
Okay, thanks.
I'd like to just quickly address the respondent's approach to, and indeed the Thompson Court's approach to the legislative history and the first acts passed after 1848 and 1902. And we believe where the court went wrong in Thompson in fashioning the broad rationale that the superintendent had to be superior to all other officers was based on a wrong presumption. And the presumption was that since the legislature did not give superior authority to another officer immediately after 1848 or 1902, that meant that the legislature could never do that, or believed that it could never do that. And we don't believe that presumption is supported at all. It is not a rule of construction that a partial act has implications as to what a future act may entail. The fact that certain powers were given to the superintendent in 1848 and indeed in the first law passed after the 1902 amendment also raises the equal inference that, for example, the power to do certain things related to rulemaking, it wasn't the rulemaking of today, but related to rulemaking, that somehow represented an inherent authority of the superintendent. The equal inference is that the legislature had to give that power. And having given that power, it had the power to take it away also.
Counsel, just for clarification, I didn't think inherent authority was being advanced by opposing counsel in this case as a theory. I heard it discussed in response to a in response to a question from the bench. And I think I tried pinning them down, saying that that's not your argument, is it? But am I missing something? Do you think it really is their argument?
We did not believe it was, Your Honor, but I was concerned by the answer to Justice Prosser's hypothetical that somehow, if that power was taken away, that the superintendent somehow maintained some role in teacher licensing, for example, if the legislature had decided that it did not, that he or she did not. But the state defendants agree with the arguments in the brief submitted by amicus and the arguments made today by Mr. Essenberg. This court has the opportunity to correct the stifling effect, if you accept the respondent's version of Thompson, the stifling effect on the evolution of public policy relating to public education in this state. That was foreseen by Justice Wilcox. There has been a gap of almost 20 years, and I think it's significant, and this court can infer that that gap in terms of the legislature not venturing into the area of the powers of the superintendent was the result of that unnecessary and unfounded broad language in Thompson. The court has to harmonize all things that have occurred in this case, including the concessions that have been made, the various constitutional authority assigned to the legislature, the executive branch, and it must harmonize all of those elements. Under the respondents, Your Honor, I see my light has gone off.
Yes, just if you can conclude quickly, please.
Yes. As we've mentioned, there are two ways to achieve that harmony, or that harmonization of those conflicting strands. One would be for this court to decide that Thompson did not control this case, and the second would be to overrule the broad rationale and permit Act 21 to go forward vis-a-vis the superintendent.
Thank you very much, and thank all counsel for just absolutely outstanding arguments and for fielding a lot of questions that I think some of you were surprised with because they weren't in anybody's brief, but it does help us a lot when you try to answer the questions that are bothering us, whether or not you saw them as the focus of your argument as you made the brief. So thank you all very much. We are now adjourned, and the court will meet in closed conference at 2 o'clock?
1:30.
1:30 is okay with you? Okay. Okay, 1:30. Thank you.